Mr. David Leon Riley was a young man who resides in San Diego, California. Riley was part of a local gang who called themselves the Lincoln Park Gang. These members reside and perform their operations in San Diego. On August 2, 2009, as part of the gang, Riley and other members opened fire at a rival gang who was driving past them. After the shooting occurred, the members entered an Oldsmobile that Riley had owned and drove off. 2 weeks later, Riley was pulled over in a different car. The car had expired registration tags, which was the reason for the stop. Riley was driving on a suspended license that day and got the car impounded due to police policy. Impounding the car is a lawful seizure and confinement of a vehicle as punishment for unpaid tickets, driving while under the influence, or driving without a valid license. Before an impound, it is routine to search the car to make an inventory of the possessions in the car. This is so the items in the car are to be returned to the owner for liability reasons before the police keep the vehicle. This is also a way police officers find contraband hidden in impounded cars, such as drugs, money, guns, and other possibly incriminating components. During the routine performance of this task, police found two guns that tie back to the shooting on the second, which put Riley at the crime scene, getting him arrested. During Riley's arrest, he had possession of his phone, which was promptly searched for any evidence that could help tie Riley back to the shooting. This action was done unprompted and without a warrant. The contents of the phone had pictures of Riley posing, using gang signs and other gang indicators. As an effort to show the police that he isn't gang affiliated, Riley moved away from San Diego. This motion was denied, and a gang expert testified against Riley, saying that his involvement with the shooting could be gang related, and the rivalry between the Lincoln Park gang and the opposing gang could be a motive for the crime. Riley was eventually charged and sentenced to 15 years to life, being put under for shooting at an occupied vehicle, attempted murder, and assault with a semi-automatic firearm. There are concerns towards this case that shed light on some of the discrepancies that got Riley convicted and charged. The main problem is with his phone. Riley's phone was on his person in the car at the time of arrest, which led the officers to believe that it is liable to a search. The question of the matter is, was the evidence admitted at trial from Riley's cell phone discovered through a search that violated his Fourth Amendment right to be free from unreasonable searches? The Fourth Amendment protects the people from unreasonable searches and seizures by the government. This means that anybody who wishes to search you must have a good reason for the search. For approved searches, a warrant is normally introduced. A warrant is a form of approval that lets you and the person meaning to search you know that you are liable to being searched. Riley, the plaintiff in this case, argues that the confiscation and the search of his phone is a violation of the Fourth Amendment, and his right to be free from unreasonable searches was infringed. This case was against the state of California, the state in which he got arrested. California defends this notion by explaining that anything available in the car at the time of being impounded is prone to being searched. They further argued that it is understood that anybody who is charged with treason or felony is entitled to have their possessions detained and possibly used against them in court. On June 15, 2014, it was unanimously decided by the Roberts Court that a warrantless cell phone search violates the Fourth Amendment's right to privacy, giving the win to Riley. According to the court, a warrantless search is prompted if the purposes are to keep the officer safe and to preserve evidence. It was determined that Riley's cell phone prompted none of those reasons. A cell phone can't be immediately used as a weapon against the arresting officer, and the data on the phone can't harm them either. The characterization of cell phones as mini-computers also helped explain the case, as computers are normally used as a place to fill with massive amounts of private information. This is a major difference between information that could be obtained from traditional sources, such as a wallet, and is seen as a breach of privacy. The court explained that if they wanted to use the phone as evidence, they could have detained it, disconnected the phone from any Wi-Fi connection, and placed the phone in a Faraday bag until a warrant is issued. Overall, the court is finished by saying that the warrantless search is still available in emergency situations. It is only permitted when the government specifically finds the reason to allow it. This case tackles a recent topic at the time. iPhones and picture-taking cell phones were still new at the time of the incident. Technology is advancing and the police most likely took this case how they would anything else. However, phones are more private and can store more than just personal photos. This case set the precedent for how phones are used as evidence in future cases. An unwarranted phone search can be the equivalent of an unwarranted house search. Thank you for watching.